I would like to say good afternoon, good evening to all my panelists. And I have no hesitation in saying that this is arguably one of the most hotly debated, discussed topics all over the place. I would just like to say that in today's day and age, when businesses all over the world are evolving at a rapid pace, most countries usually design their local laws to suit their local needs. But in the evolving global and business environment, with cross-border transactions, global lending, etc., these local laws sometimes fall short when businesses span across countries and continents. As far as India is concerned, IBC has been a real game changer for the lender community. It has substantially changed the behavior of defaulting companies and errant promoters. Although there is still one area which needs to be plugged to ensure that the lenders are able to recover their dues to the full permissible extent, and that is cross-border insolvency. This issue recently has come to light in some of the critical cases like the Jet Airways cases and the Videocon case. The Insolvency Law Committee in India has submitted a report suggesting incorporation of the model law into IBC with certain modifications and variations, of course, to the model law. However, this model law, as revised by the committee, has not yet been adopted and incorporated into the IBC. Since there is no cross-border insolvency in India, the ability of the lenders to go after the overseas assets and overseas lenders to go after assets of companies in India is severely affected. And at times, these assets are created by promoters and companies, at times in a clandestine manner, to ring fence them from the prying eyes of the lenders. Thanks to the Panama Papers, Pandora Papers, etc., we all know how many promoters, how many politicians, how many companies have parked their assets in tax-friendly jurisdictions. It would make lenders' life a lot easier if we in India would consider and recognize the model law as approved by the committee and incorporate them into our own law. In order to understand this model law and how it has spanned out various jurisdictions, we have this panel of distinguished practitioners to help us understand. If I can just straight away go to Rishi first. Hi, Rishi. How has this model worked in Singapore? If you could just throw some light on that.
Hi, Nirav. Hi, everyone. Good afternoon. Yes, sure. Very happy to. So Singapore is a model law jurisdiction and has adopted the Yuan Central model law on cross-border insolvency pretty much in its totality. Just by way of background on the model law, it's really a framework or a route by which a foreign insolvency representative can apply to court to seek recognition of the foreign insolvency proceeding. Now, in Singapore, we've adopted a slightly broader approach in that in the Singapore enactment of the model law, the Singapore courts can also recognize restructuring proceedings as well, or proceedings relating to the adjustment of debt. So it's not just on recognition of insolvency proceedings, but Singapore courts have the power under the Singapore model law to recognize foreign restructuring proceedings as well and give effect to them. So in terms of how it works, so a foreign office holder will submit an application to the Singapore courts, and provided that certain conditions are met, the application is pretty much stamped and those foreign proceedings are recognized in Singapore, and the courts will give assistance to that foreign office holder to give effect to the recognition and give assistance to the foreign office holder in relation to the foreign proceedings. And give some relief measures if required. So in terms of the support that a Singapore court can provide, the model law distinguishes between foreign main proceedings and foreign non-main proceedings. And depending on the type of proceedings that's recognized, different relief measures and consequences flow from that recognition. So a main proceeding is really one where the debtor has its center of main interest, this comey. And this comey is kind of central to the model law concept and the framework. And it's presumed usually to be where the company has its registered office. However, that presumption can be rebutted, and you can show that a comey of a company is actually in another jurisdiction. So if a Singapore court recognizes an insolvency proceeding as a main proceeding, then the benefits that flow from that include providing an automatic stay on any creditor action or enforcement proceedings against the debtor or its assets in Singapore. So it's quite a powerful recognition tool for foreign insolvency office holders.
Oh, that's very interesting. Let me go now to Peter. How has it worked out in Australia, Peter? If you can just shed some light on that.
Yeah, no, absolutely. Look, thanks very much for having me. It's been a relatively successful piece of legislation. So similar to Singapore and other overseas jurisdictions, Australia effectively enacted the model law, the answer trial model law via Australian legislation, being the Crossborder Insolvency Act in 2008. And so that's really enabled the participation by foreign creditors in our local insolvency proceedings, facilitated cooperation between courts and insolvency practitioners. It allows a person administering a foreign insolvency proceeding to have access to the local courts in Australia, and it also sets out the conditions for the recognition of an Australian insolvency proceeding. So similar to the overseas jurisdictions, we have the same concept around a comey. So a lot of the case law that's been had in Australia has been whether or not Australia or an overseas jurisdiction is the centre of main interest in respect of that relevant debtor company. And that obviously then feeds in really heavily into where the model law applies, and if it's the local law or the foreign law. In Australia, most of the proceedings have been around the recognition of foreign proceedings. So they've been overseas insolvency practitioners who have come to this jurisdiction to have the overseas proceedings recognised in Australia. Really interestingly, there's been a couple of cases recently where those proceedings haven't been recognised. And I might just touch on those really briefly, but one of those decisions is Hydrodeck Group. And this was a public company incorporated in the UK, and it was registered as a foreign company carrying on business in Australia. It had dormant subsidiaries in the UK, Australia and Japan, and a trading subsidiary in the USA, which held all the valuable assets. So in this case, an Australian creditor obtained judgments against the company for 1.6 million Australians, and that ultimately wasn't paid. And so the Australian company commenced winding up proceedings against this relevant entity, Hydrodeck. Sort of in between that happening, the company entered a moratorium process under the UK Insolvency Act, and the monitors appointed under that act in the UK applied to the New South Wales Supreme Court for the Australian winding up proceedings to effectively be stayed on the basis that the UK moratorium process is to be recognised. Interestingly, in this case, the New South Wales Supreme Court found that the comey of that entity was in fact not in the UK or Australia, but it was in the USA. And that was on the basis that its only trading entity was in the USA. The USA was the company's key market, and the main creditor of the corporate group was located in the USA. And so what that meant from an Australian law perspective, and it's a good consideration of how the model law works, is that the moratorium process in the UK, because it did not constitute a foreign main proceeding under the model law, Hydrodeck was not entitled to recognition of the UK moratorium to stay the Australian winding up petitions, and therefore the winding up petitions were able to continue. And some of the evidence that was put forward as to not stay that winding up proceeding under Australian law, utilising the model law concept, was that the company was insolvent. It was unlikely that it would be saved by the UK moratorium. The amounts owed to Australian creditors were material, and ordering the winding up and appointing a liquidator would enable investigations into potential voidable transactions. So I think that's a really good example of the operation of the model law, but also the importance of ensuring that that comey is actually recognised such that the proceedings can have an effect under the Australian jurisdiction.
That's very interesting, actually. Now, if we talk about the Indian context, let me straight away go to Mr. Sachdeva. The IBC has section 234, which talks about entering into agreements with foreign countries, for enforcement of provisions of IBC. It also has section 235, which provides, a letter of request can be sent to another country in certain cases. However, no effective steps have been taken to implement these provisions. How do you see, this thing panning out in case of a cross-border element involving an insolvency in India? Mr. Sachdeva, we can't hear you. You're on mute.
Thank you, Nirav.
Yes.
While Section 234 and 235 of IBC, they deal with the cross-border insolvency. And as you said, Section 234 deals with the agreements with the foreign countries and 235 deals with the letter of request to the foreign country. Now, these are the two sections for enforcement of the provisions of IBC with regard to assets of a corporate debtor which is located abroad. But so far, these sections have not been notified. But there's a peculiar issue. Jet Airways case is something which is, where while Section 234 and 235 was interpreted by NCLT, looking into the aspect that there were certain other proceedings initiated in the Dutch court.
Right.
Just to give the factual perspective for the purpose of this particular seminar, and there were two parallel proceedings which started in the Jet Airways case. One which was filed by German creditors in Dutch court, which was prior in time, and second filed by the lenders consortium lead by State Bank of India in the NCLT Mumbai. Now, what happened? After admission to CIRP at NCLT Mumbai in India, the administrator appointed by Dutch court, he came to the NCLT and filed an intervention application. And the bench was apprised that insolvency proceedings against corporate debtor have already been initiated and judgment of Dutch court was placed before the bench. The NCLT Mumbai held that since Section 234 and 235 of the Act are yet to be notified, hence, this is not something which is enforceable, and NCLT, being the adjudicating authority, is not empowered to entertain the order passed by a foreign court.
Right.
And primarily, they said since the registered office of corporate debtor, which is Jet Airways, is situated in India, and NCLT Mumbai will only have jurisdiction in respect of the CIRP proceedings. Their reasons were there were four reasons they set out. First, they said question of running two parallel proceedings does not arise, and the provisions of IBC do not allow such two parallel proceedings to continue. Then they also came to the conclusion order passed by the Dutch court for the company registered in India is a nullity of an issue. And this is completely something which cannot be recognized by the Indian NCLT Mumbai. They also said Section 234 of IBC is not yet notified, which provides application of provision of this code in relation to assets or property of a corporate debtor, which is situated in a country outside India. And fourth reason, they said, Indian government has no such reciprocal arrangement with government of Netherlands. Therefore, none of the courts has any jurisdiction to pass any order under IBC where assets or properties of the corporate debtors are situated in a country outside their country. The order the order of the NCLT was appealed before the NCLAT, and NCLAT set aside the order of the NCLT. NCLAT came out with something, they devised a cross-border insolvency protocol. That was something very interesting.
Right.
This cross-border insolvency protocol was in line with the model law. They said Indian resolution professional and Dutch administrator, they can work in tandem with each other. Under the protocol, India was recognized as comey, a center for main interest, and Netherlands as non-main insolvency proceedings. So what happened? The analysis, if you go by this, they allowed the Netherlands proceedings to be recognized, and the order said that while Dutch trustee is equivalent to resolution professional of India, and as per law, he has a right to attend the meetings of the COC, which is Committee of Creditors. However, he shall not have any right to vote in such meetings. That was the decision given by the NCLAT. And they also said that Dutch trustee, which is the administrator, will work in cooperation with the resolution professional of India. And if any suggestion is required to be given, he may give it to the resolution professional. Now, the takeaway, what comes from the NCLAT is something, first, Netherlands applied principle of territoriality, which limits jurisdiction of courts only to the assets present within the charge of the territory of state and do not allow the charge of assets in foreign countries. Secondly, India followed universalist approach, which means institution of insolvency proceedings by one court in the jurisdiction where corporate debtor is domiciled or has its registered office. So decision of NCLAT was something which was in line with the objective of the model law framework. And I think that was a win-win situation for both India and Netherlands, where these things were recognized.
Right.
And the order of the NCLT, which was saying we are not going to recognize the foreign proceedings for any insolvency, was something which was set aside by following a protocol and devising a methodology which NCLAT did it wisely.
Right.
We also take into consideration the other one, which is the Videocon, where there were 15 resolution applications which were filed against 15 different group companies. The NCLT Mumbai, they granted substantive consolidation of 13 companies of Videocon Group on the basis that group worked as a single economic unit. Now, the other companies were in different jurisdictions, but these companies, what they found had voluntarily formed an obligor and co-obligor structure under the financing documents, in terms of which the corporate debtors were jointly and severally liable in respect of the obligations, and their assets and business functions were held by the NCLT on account of same as intricately intertwined. So they followed the principle of the consolidation and held that for the purpose of CIRP process, the foreign oil and gas assets and properties, including any claim interest therein, or Videocon Group, held through foreign subsidiaries of the corporate debtor, will be regarded as property of the corporate debtor. So these two decisions somehow, while there is no framework, they recognize the concept of consolidation, and also taking into account the foreign companies' jurisdictions, and trying to say that this can be done in a single by following the model law. In the test for consolidation in Videocon, they followed a checklist approach from the US to provide for 14 touchstone factors like common control, common directors, common assets, common liabilities, interdependence, etc. And based on which they said, yes, this can be consolidated. This is what I think these two decisions, while there is no framework, but yet it supports the idea that even if there is a litigation or proceeding in a foreign court with regard to something which is relating to the insolvency, it can be dealt with by following the model law approach.
You're absolutely right, Mr. Sachdeva. And I think, as you use the right words, that the NCLAT devised a protocol which kind of allowed all the parties to largely follow the model law. And having said that, I still would like to believe that the judgment passed by NCLT in the Jet Airways case was on the basis of the literal interpretation of IBC. And I would believe that they are not strictly wrong in what they've held, because the fact still remains that there is a lacuna in our law as far as the recognition of a foreign insolvency regulator is concerned. So in that sense, I believe what an NCLT's interpretation was fair and correct as far as the position of IBC is concerned. However, NCLAT went a step ahead and devised the protocol, which basically eventually led to a win-win for all the parties. So yes, I take your point that this actually has been quite a win-win for all the parties, especially the two cases that you mentioned. But I would imagine that life would have been a little bit more simpler if the model law, as recommended by the committee, would have been incorporated under the IBC. But maybe that's for another day. So I would like to just go to Joanne for her comment on what the position in Hong Kong is and what approach are the courts and the insolvency professionals taking there.
Hi, thank you, and thank you. Good afternoon, everyone. Just to be clear, so I'm in Hong Kong, but I'm going to be giving you the offshore perspective, so BVI,
yes.
Bermuda and Cayman law. I'm going to touch briefly on Hong Kong, but I'm not a Hong Kong lawyer, so put that out there at the start. Look, similar to India, none of the offshore countries that we work in, so again, Bermuda, BVI and Cayman, are model law countries. The BVI has actually enacted the provisions, but they're not enforced. So you'll see them in the Insolvency Act if you have a look, but they're not enforced. But what we've done, and actually sounds similar to what India's been doing, offshore is to think about other ways to provide assistance. The offshore courts are generally very willing to assist. When we're talking about a foreign liquidator of a foreign company coming into those courts and saying, look, we need assistance here with respect to, for example, assets which are located in those jurisdictions. So if we look at, for example, Bermuda, Bermuda is entirely common law based. So where you have assets which are located in Bermuda and a foreign liquidator of a foreign company needs assistance, we can go to court and ask the court for the normal types of orders that you would seek, including those that you might seek under the model law, so turnovers and stays and things like that. Cayman's gone one step further and actually put those assistance provisions into the statute itself in Part 17. So again, the normal types of orders you'd expect, information gathering, that type of thing. There isn't a restrictive list or a list of countries that either of those two jurisdictions will help. It's basically will help anybody. The BVI is slightly different. As I said before, the model law provisions have been brought into the statute but not brought in force. And so there's been quite a lot of debate in the last few years about the extent to which the common law actually survived in circumstances where the legislature brought in the model law, but again, not in force. Various judgments back and forward, the most recent position being that the common law did survive, in the sense that you can recognise an offshore or a foreign liquidator, rather. And the court in BVI has recently said it's with regret that you cannot then provide assistance to them. So you can recognise them but not assist them. There is another section in the BVI statute which provides for orders in aid of foreign proceedings, so slightly different focus. That particular section has a list of designated countries. India is not one of them. Australia and Singapore are, if that, sorry, not Singapore, Australia is, if that helps, and Hong Kong is. Yeah. You know, and again, that provides for various orders that can be made by the court for particular designated countries. I must say, I don't know which country, like why certain countries have made it onto the list and others have not. The list is just what it is. But all hope is not lost in the BVI in the sense that we can go to the court in BVI and seek recognition. And it may be that we can do things in the BVI, for example, rectification, or if, for example, you have a foreign liquidator of a company that owns shares in a BVI company, which is quite common. So you'll see a BVI subsidiary company. There's various judgments that confirm the fact that the foreign liquidator acting as an agent in place of the board of the parent company can then go ahead and change the board, for example, of the BVI company for the purpose of then taking control, coming down through the chain of assets. And just to put that in context, most often we see offshore tends to be Bermuda or Cayman up the top. We might have a BVI subsidiary in the middle, and then we might come down to Hong Kong and then right through the mainland if we're talking about sort of Asia and the mainland type assets. So that's why it may not be, although BVI says that we can't necessarily assist everybody, we can certainly do the things that we probably need to do. That is in respect of a recognition of a foreign liquidator appointed to a foreign company. So similar to what the other panellists were saying, in the sense of people coming in and asking for help with asset recovery and things. In Hong Kong, it gets a bit more interesting because 75% of the main board companies in Hong Kong are actually offshore. And so there's been quite a bit of debate about the extent to which the Hong Kong court can wind up with what they call a foreign company, which is the offshore company. And then the question becomes, well, what can that liquidator do? Because they're a Hong Kong appointed liquidator of a Cayman or Bermuda company. You know, what do they do? So again, there's been various decisions or considerations of that. And the outcome really is that that Hong Kong liquidator can't necessarily do a lot if you've got the type of structure that I've mentioned before, where you end up with intermediate holding companies, where you can't take a Hong Kong liquidator of a Cayman company owning BVI shares and get that person recognised in BVI. So the messaging very much is, you know, go back to the place of incorporation, get your liquidator appointed there, and then seek recognition in Hong Kong. as I said before, I'm not a Hong Kong lawyer, but there are cases out of Cayman, for example, where the Cayman court has taken a Hong Kong liquidator, Cayman company, and permitted that liquidator to actually convene a scheme meeting, for example. Or another case where a Hong Kong liquidator was permitted to commence a Cayman winding up proceeding. So again, the offshore courts are sort of trying to help within the confines of what they can do, with a view, of course, to maximising recovery to creditors. So the only other thing I'll add, again, in this part of the world, there's been some quite recent developments in terms of an interesting line of cases in relation to the recognition of so-called soft touch or light touch liquidators. And that is the expression we use for liquidators appointed offshore for the purpose of restructuring. We usually do that through a provisional liquidation process. And I think it's fair to say that the Hong Kong court has cracked down a little bit in the sense that we used to be able to go offshore, put in a light touch provisional liquidator and come to Hong Kong and seek effectively a recognition of the stay that you would get offshore for the purposes, again, of restructuring. The Hong Kong court has been questioning us to the extent to which you can or should be able to do that, whether or not that light touch process is a collective insolvency proceeding. And the position now effectively is you can come to Hong Kong and seek recognition, but you may or may not get a stay, and you may or may not get sort of adjournments of any winding up proceedings commenced here with respect to that company. And I think that's frankly a good decision in the sense of it encourages people to move things along. You know, if there's a restructuring to be done, it should be done. But if not, then the creditors in Hong Kong are then able to exercise their right to have the company wound up as a matter of Hong Kong law. The only other interesting development, I think, just in the general theme of cross-border insolvency is a recent mechanism that's been agreed between the Hong Kong government and the mainland government with respect to a recognition of liquidators across into the mainland. It came into effect on the 14th of May this year, so it's very new. We've just done the first application for a letter of request to come from the Hong Kong court. So we have a Bermuda light touch appointment. They've come through, put in some liquidators into Hong Kong themselves, obviously, but they put liquidators into a Hong Kong subsidiary. Those liquidators are now going to the mainland, and they're seeking recognition of their appointment as liquidators of the Hong Kong company, again, to get through to the mainland assets. And hopefully that will be successful. It's the first time it's being done. And again, really the main strategic goals here are, when you're looking at the offshore structures, is we want to get control of the structure. We want to use the offshore world, but also use the Hong Kong angle as well, with a view to coming down into the mainland and taking control of the structure for the purposes of recovering assets or restructuring, or whatever the outcome is that's going to be best for the stakeholders.
Thank you, Joanne. One interesting point I just like to ask you. You made a point that these offshore jurisdictions like BVI, they recognize but they do not assist. Can you elaborate a bit on that? Because I find it very interesting.
Yeah, and I must admit, I wondered myself what the difference was when I was looking at the cases, thinking, well, hold on, what is the difference? And I think it's got to do with recognising the power of the liquidator to act for and on behalf of the entity. So again, I'm looking at more of it effectively an agency. So who is it that has control for and on behalf of the foreign company? So if you're not in the list of designated countries, we can't necessarily immediately do all of the things that you would do under the model law. But for example, if the foreign company, now controlled by its foreign liquidator, wants to bring proceedings, then you get your order recognising the authority of the foreign liquidator to bring those proceedings for and on behalf of the company. Seeking rectification of a register of members. So, for example, if you've got a foreign bankruptcy trustee and the assets of the bankrupt vest in the trustee as a matter of the foreign law, you can come to the BVI and say, well, actually, I'd like you to rectify the register of a BVI company to show that as a matter of the foreign law, those shares now vest in me. So it's not, all hope is not lost. We don't necessarily have all of the assistance provisions that exist elsewhere. But I think there's enough, if that makes sense. So if you are looking at a BVI company, you've got some BVI assets that you need to recover, then, shamelessly self-serving, but, do speak to the offshore people, because there are things we can do.
No, I suspect there will be some activity on that front, because as the revelations of Pandora Papers have shown us, that there are many people who've parked funds or assets in these tax havens. And if these cross-border insolvency gets legislated, then there will be some liquidators or insolvency professionals who will come knocking on the door. So that is something which may happen sooner than later. Let's hope. But the first step, for at least for India, is to recognize the model law as a part of the municipal law. Thank you so much, Joanne.
Thank you.
Let me just come back straight to you, Rishi. In terms of typical issues that may arise while implementing the model law in Singapore, what are the typical kind of cases do you see that are being litigated in courts?
Yes, I mean, I think as Peter said, I think a lot of questions around how do you work out where the comey is, at what date do you work out where the company's comey is. So a lot of that has been around this question of comey, and as with all legislation, it's all in the small print and the defined terms. You've got to really look at it. But I think the Singapore courts have taken a very pragmatic approach in terms of the comey questions. And in Zeta Jet, to just touch on that case, the Singapore court looked at two issues. One is working out the time at which you assess the company's comey. And secondly, what factors you look at when determining a company's comey. So different jurisdictions obviously have different times at assessing when a company's comey is. In Europe, they look at when the foreign proceedings were commenced. That's when the time which you look at where the comey is. In the US, it's when the application for recognition of those foreign proceedings is made. So it's a much later date.
Right.
So the Singapore court actually adopted the US approach, and we seem to do that a lot here in Singapore, and said, yes, we'll take the approach that the US have taken. We don't look at the comey of a company when the foreign proceedings were commenced. We look at it when the foreign insolvency office holder comes to Singapore and puts their application in. And the reason why they do that is because the Singapore High Court said we have to be pragmatic here. A company may have changed its comey over that time period to get a connection to that jurisdiction. There may be a legitimate reason for it to have to shift its comey. And therefore, we shouldn't be looking at it at an earlier date. We should be looking at the comey assessment at a later date to give that company enough evidence to say, actually, its comey is in the jurisdiction where it filed for insolvency proceedings. So the Singapore courts, I think, have taken a really pragmatic approach in terms of understanding where a company's comey is. And they're open to, I think, good forum shopping and finding the right jurisdiction in which to carry out a restructuring or an insolvency process.
Right. So, I mean, I have a question which probably could be common to both Rishi and Peter. And no, either of you can just jump in there. What happens in a situation where there are two jurisdictions whose municipal law or insolvency law are in conflict with one another? How are the courts in Singapore or Australia dealing with these kind of conflict issues between the two jurisdictions? Anybody can take it. I mean, I'm fine with it.
Maybe I'll go first, because we just had a case recently on that issue where the Court of Appeal actually had to step in. And it was where there were parallel proceedings in Malaysia and Singapore. Now, Malaysia doesn't have the model law implemented. It doesn't really recognize Singapore jurisdiction, but Singapore obviously has the model law and recognizes the proceedings in Malaysia. So we had a Singapore creditor with Singapore law security with a Malaysian company that was being wound up in Malaysia. The Singapore creditor went to the Singapore courts and said, I should be able to enforce my security. The Singapore Court of Appeal said, yes, hang on, let's look at this. We've got the model law implemented. So if you look at where the main proceedings are, those are in Malaysia. It's a Malaysian company. It's being wound up pursuant to a Malaysian process. So there's no argument that the main proceedings are in Malaysia. So pursuant to that, if you've got main proceedings opened in another jurisdiction, there should be an automatic moratorium. So you technically, you shouldn't be able to enforce your security. But then when we look at it with our Singapore law eyes, under a Singapore law winding up, secured creditors can enforce their security. They're not prohibited from enforcing their security. So if we apply that exception here, we shouldn't go beyond that. And notwithstanding it's a Malaysian winding up, yes, Singapore creditor, you can enforce your security. So the Singapore courts have, again, I'd say, taken a very pragmatic approach in terms of, yes, applying the model law, but also protecting secured creditors and using the kind of public policy exceptions appropriately to give the right balance, I think, to the application of the model law.
Okay, Peter?
Yeah, look, very, very similar here. I think that the first sort of important determination is around the comey. And the recent cases in Australia have really looked at, which I find interesting. One of the main determinants around comey is where the company's creditors are. So I think that's the key consideration for the Australian courts. But similar with the Singapore experience, if there are sort of extenuating circumstances related to fundamental principles around enforcement of rights, particularly around secured creditors, on the basis that they've registered appropriately under Australian law, they're not giving up those rights purely because they're sort of locked into a foreign insolvency proceeding.
Right, right. So, I mean, Rishi, since you touched upon the public policy issue, how sticky is that subject? I mean, specifically when we talk about insolvency proceedings, because, it is, I mean, I don't know if Singapore law actually defines what a public policy is, or for that matter, Australian or in the other countries. But, it's been an extremely vexed issue in India as well. We have had some degree of clarity thanks to our Supreme Court judgments. But that, of course, the context was under the arbitration law. But the Supreme Court has tried to crystallize what public policy should be. How are the Singapore courts or Australian courts looking at the public policy argument? What exactly would constitute a public policy when it comes to a cross-border insolvency between two jurisdictions, one of which may not have signed the model law?
Yeah, it's a really good question. And I was looking at this earlier because it's very broad. When they were debating implementing the model law in Singapore, one thing they considered is whether it should be based on reciprocity. So provided one jurisdiction has adopted the model law, then we'll recognize their proceedings if they recognize ours.
Right.
And then the Singapore court said, okay, no, let's do away with that. And we'll rely on this public policy exception. So if something doesn't feel right, we can always say it's against public policy. So it's not really been tested yet. I mean, it was tested in that Court of Appeal case, and they did touch on the public policy argument and say, okay, let's look at this from both the model law perspective and what we would do here in Singapore. And yes, it's important to protect secured creditors' rights in this case, in this instance, where they have a bona fide case. But there's no kind of set criteria as to what constitutes public policy. And I think it's more to the discretion of the courts to exercise their judgment.
Sure. Peter, is that the same way Australian courts look at it?
It's very, very similar. I mean, you can see sort of elements and principles around the public policy. So in the case, as I mentioned previously, it talks about, what's in the best interest of creditors as a determining factor in whether or not there's going to be a recognition, whether or not the company can be sold. So saved, and those types of considerations which are around sort of public policy, but there's no absolute definitive factors as to what they're going to look like. But it does influence the decision making, certainly.
Right. Joanne, any public policy issues arise in any of these, offshore jurisdictions?
It's not something that's really, really being focused on. And I'm not suggesting that the courts don't focus on what's in public policy in the jurisdictions, but rather the approach that's been taken offshore is more obviously wanting to protect creditor rights, but also a cooperative approach. And so, finding ways, as I said earlier, there were a couple of decisions where the Cayman court's taken a view that, notwithstanding the fact that there's no specific mechanism to take certain actions, that they will, because overall it's in the best interest of the body of creditors to facilitate, a restructuring process. So I would like to say that I think the approach of the offshore courts is more permissive rather than being protectionist. which is helpful when you've got foreign creditors and people wanting to come in and seek assistance. There is a public policy consideration in all of those jurisdictions, but I won't give you any specifics on that being.
Sure, thank you, Mr. Sachdeva. As far as the Indian law is concerned, where do you go from here? We have already been 5 years on with respect to IBC. We have an insolvency law committee which has given its recommendations, variations and changes to the model law, but that's not yet been adopted. I mean, how do you think it will proceed from here? And will things keep getting difficult for lenders till such time this model law is incorporated into our IBC? What are your thoughts?
Yeah, so I think in the absence of framework for this cross-border insolvency resolution, there are several issues and there are several questions which remains, unclear. Forget about the Jet Airways and Videocon case, while those were the cases which were dealt with by NCLT and CLAT. See, if today the insolvency proceedings have commenced in India for a particular debtor who has assets abroad, now what are the measures to ensure that such assets will not be subject matter of a parallel proceeding to that foreign jurisdiction? That's the first issue.
Right.
Second, if there are existing concurrent insolvency proceedings in several jurisdictions in relation to the debtor and its assets, and if there is no pragmatic approach of followed or adopted by the NCLT and CLAT, or let us say they stick to the first principles like NCLT did it in Videocon, what would be the consequences? Therefore, according to me, there is a need for a model law. While if you go by the NCLAT decision in the Jet Airways case, they applied the principles of the model law, which is the cooperation and coordination principle, and the relief principle, and also a recognition principle, which three principles were applied, where they said cooperation and coordination should take place between two jurisdictions. And they allowed the administrators of the Dutch court to participate in a manner where it was more of a cooperation so that the assets can be protected. I think going forward, this model law approach has to be model law, and the recommendations of the committee, those should be adopted, and section 234 and 235 should be given recognition insofar as the enforcement is concerned with regard to the proceedings which are happening in other jurisdictions. And we follow the committee approach. If we are an Indian company, we have a registered office in India, yes, committee approach should be followed.
Yes.
But having said that, today, in the absence of framework, I think things are not clear. We require a model law which should be adopted as soon as it is, done by the government. So
absolutely, I couldn't agree more with you, because maybe Jet Airways and Videocon probably maybe the exceptions rather than the rule, but we've had and we've seen many instances where insolvencies and large insolvencies that are going on in India, where the company and the promoters have, to the knowledge of all the lenders, kept assets out of India because of the lack of model law's presence under our municipal law. It makes it that much difficult for the lenders to go against those assets. So what really is happening is that lenders, instead of taking up a lesser haircut, they end up taking a much larger haircut. And once the insolvency closes and the restructuring of the resolution is closed, effectively the remedy of the lenders those assets effectively is lost. So yeah, I couldn't agree more with you. And I think I don't think there's anybody who believes that incorporation of the model law into our local law, the time for that has come, and it is now. And I think we can take an example out of what's happening in Singapore, what's happening in Australia and UK and other jurisdictions where the model law actually is working quite well. And we also have an example of something similar where India is a signatory to the New York Convention for Recognition of Foreign Awards, and that actually has worked quite well. And I really don't see any reason why the model law, once incorporated, should not work well, and it will only help the lenders recover more money, which are of course public money. Having said that, I think we are at the end of our session. Thank you so much. Thank you, Rishi. Thank you, Peter. Thank you, Joanne. Thank you, Mr. Sachdeva. It was great chatting with you, and it was great learning about the other jurisdictions and how the cross-border insolvency and the model law is working in these jurisdictions. Thank you so much.
Thank you very much. Thank you.